I'm here basically as an interloper, really, in with two regards. I'm not an OT, and I'm not an expert on capacity. I'm the London and South East Regional Advisor for Foundations. The reason why this topic was raised was I had an email from a colleague in the London region who's a caseworker for a home improvement agency, and she'd received a number of recent referrals from OTs where capacity to make decisions was an issue. So I shared this with colleagues in Foundations, and Lorraine thought it'd be an interesting discussion topic for this forum. I should also say that on the agenda it links capacity with dementia, but it's also an issue which may affect other potential DFG applicants, for example, including people with dementia. So I'm going to be focusing more on capacity rather than capacity and dementia, and hopefully you'll be able to I'm just opening my presentation, so hopefully you'll all be able to see that. So I'm not an expert on capacity, so my aim is really to outline approaches regarding capacity assessments, and then to provide an opportunity, as has been the case with the whole session so far, for you to provide an opportunity to share your own experiences, and also just to identify the extent to which this is a common concern about which further guidance could be useful. And I'll come back to that in a tick. So you'll probably be all familiar with this, and this is really just a refresher, so I'm assuming that many of you will be familiar with these sorts of issues already. But the Mental Capacity Act has 5 key principles. So one is, the first is a presumption of capacity, that every adult has the right to make his or her or his own decisions and must be assumed to have capacity to do so unless it's proved otherwise. So the starting point is in a presumption of capacity. And building all on from that, the approach the MCA takes is that individuals should be supported in every way possible to make their own decisions and to exercise their capacity before there's any action taken on the basis that they cannot make their own decisions. The third issue is unwise decisions. So there is not necessarily a right decision to take. It's very much down to the individual. And just because an individual makes what might seem as an unwise decision, they shouldn't be assumed to lack capacity to make that decision. And the fourth issue is best interests. So where a decision is made on behalf of a person who may lack capacity, it must be done in their best interests. And I'm going to come on to talk a bit more about that in a tick. And finally, the fifth key principle is that where anything may appear to restrict someone's freedom, that the course of action should be taken which entails the least restrictive option. So just to reinforce the presumption of capacity, so no one can be labelled incapable simply because they have a particular diagnosis or medical condition. So simply because someone has dementia, simply because someone has a learning disability, doesn't mean they are incapable of taking decisions, that they lack capacity. And the other important point linked to that is that the assessment of capacity is not a generic decision about whether someone has capacity or not. It's specific to the decision needing to be made. So it's not a generalized assessment of capacity. Now, where someone lacks capacity to make a decision in a particular set of circumstances, a decision can be made on behalf of that person by an agreed decision maker, as the phrase is, so long as the person has been assessed as lacking capacity and that any decision is, as it says there, necessary, proportionate and the least restrictive option. So that's referring back to one of the principles in the MCA Act, in the MCA rather, that the decision is taken in the person's best interests. And again, this reflects the 5 principles, and that any restraint involved must be necessary to prevent harm to the person. And restraint in terms of adaptations could, for example, involve restricting someone's access to different parts of the property, restricting access using door locks, using window locks to prevent someone climbing in and out of windows and so on. So decision making, a best interest decision can be made by someone acting with the person concerned. It could be best interest decision could be made by an OT, by a social worker. It could be made by someone in a home improvement agency, where there is no one who has a registered lasting power of attorney in place, or where there is no deputy for property and affairs who's already been appointed. And it's important to note that it's very useful or very important to keep accurate records of such decisions, that some decisions require a formal assessment of capacity, for example, making a will or signing a legal document, and that the more significant the decision, the more formal this process should be. So that then raises the issue of, for example, if you're talking about the capacity to sign a DFG application form, is that a formal legal process which requires a formal assessment of capacity? Is that something which can be done on the basis of a best interest decision, or is that something where you should really be exploring the Court of Protection or some alternative route? So with best interest decisions, there are again a set of key principles involved, that the individual should be involved as far as possible. So even if a decision has been made that that person does not have capacity in this particular set of circumstances, every effort should be made to involve that individual and to assess what their wishes and preferences would have been. So that's going to involve consulting and involving people who know the individual, identifying all the relevant issues and circumstances, looking at similar situations, looking at their background, using past knowledge of the individual. And I should just say that, as people will no doubt realise, the MCA and the Code of Practice are long and complicated documents. There is NICE have produced guidelines, Guideline 108, relating to decision making and mental capacity, and there's a reference there to it, which is a very useful document to guide people through this situation. I should say that there was recently, I think it was back in May last year, Paul Smith posted on the DFG Facebook page an inquiry, or just a question really, about how people respond to submissions of DFG applications for someone who is deemed not to have capacity. There were, I think, 52 responses to Paul's query. 86% of those respondents used a best interest approach to a DFG application. 4%, so a relatively small minority, insisted on a formal deputyship being in place, and 10% used some other process, but what that other process wasn't specified. So having outlined some of the processes involved with regard to capacity, it's really over to you for comments and questions, contributions. Just wanted to raise some general points, and then just to get the kind of discussion going, I've got a couple of scenarios which are based on situations which have been presented to me